This video will help you prepare for the legal reasoning section of the UG Clat 2020 exam, including suggestions and resources to make sure you are exam ready. To begin with, let's go over the syllabus and skills that you will be tested on. In the legal reasoning section, you will be expected to read passages of around 450 words each. These passages may relate to fact situations or scenarios involving legal matters, public policy questions, or moral philosophical inquiries. While you do not require any prior knowledge of law to answer questions based on these passages, you will benefit from a general awareness of contemporary legal and moral issues to better apply general principles or propositions to the given fact scenarios. The questions in this section will be based on material drawn from sources that include news articles and books associated with topics of law, as well as certain passages created specifically for the exam. Unlike the previous year, where the proposition and factual context was clearly presented, this year the focus is on you doing the work to find the facts and applicable rules by yourself in a situation. We believe this is closer to real-life practice. The purpose is not to test the knowledge of law, but the application of rules to a factual context based on the constraints presented to you. Knowing and being able to reason is much more useful than knowing rules. Engaging regularly with legal materials in popular news will give you all the factual context you need. You need not be reading heavy legal tomes. Each passage will be followed by a series of questions that might ask you to identify the principle or principles from the passage and apply it or them to the facts in the passage or another set of facts. Understand the impact of a change to the principle or the facts on how the altered principle may apply to such altered facts. Or identify potential outcomes of the principle on various fact situations that may not be covered in the passage with or without alterations to the principle. After familiarizing yourself with and practicing questions in these formats, it would help to keep in mind a few important points while approaching the questions in the legal reasoning section of the UG Clat 2020. One of the biggest differences in the pattern of the legal reasoning section of the UG Clat 2020 over previous years is that the principle and facts will not be supplied separately to you. As such, the first thing you should do is read through the passage carefully and identify the principle or principles set out in it. Once you have done this, read through each question carefully to see if it relates to the same facts as are set out in the passage or a separate set of facts, or perhaps the facts set out in the passage with some alterations. Now that you have both the principle and the facts identified, try and break down the principle into smaller parts. For example, a principle may say, a person who operates a drone at a height in excess of 500 feet in a public place is guilty of nuisance. In such a case, you should be able to identify the 3 requirements set out in the principle for nuisance. Firstly, that the person in question should have been operating the drone. Secondly, that the person should have operated the drone at a height in excess of 500 feet. And thirdly, that this should have occurred in a public place. Only if all 3 parts of this principle are satisfied by the facts can you assume that a person is guilty of nuisance. When breaking a principle down into its parts, be careful to pay close attention to what we call or and conditions. The example we saw above had "and" conditions, that is, all three parts must be satisfied for a person to be held guilty of nuisance. On the other hand, if the principle were worded as follows: a person who operates a drone at a height in excess of 500 feet or in a public place is guilty of nuisance, you would have had one "and" condition and one "or" condition. In this situation, for a person to be held guilty of nuisance, the following conditions must be satisfied. They should have been operating the drone, and such operation should be at a height in excess of 500 feet or in a public place. These small changes would result in a big change in the outcome. In the first case, a person operating a drone at a height of 300 feet in a public place would not have been guilty of nuisance, but in the second case, that person would have been guilty of nuisance. As you can see from the above, small changes to the wording of a principle can make a big difference to the outcome of a question. Similarly, small tweaks to the facts can also have a big impact on the outcome of a question. Suppose you are working on a question that has either of the principles above, and the facts state: Rahul takes his drone to a public market where he meets his friend Sheila. Sheila asks Rahul if she can fly the drone for a little while, and he agrees. Sheila then takes the drone and flies it to a height of 600 feet above the market so she can get a panoramic shot of the market. Is Rahul guilty of nuisance? While your first instinct in this case may be to say yes, slow down. The question asks if Rahul is guilty of nuisance, but the facts tell us that Sheila was flying, that is, operating the drone. Therefore, Rahul cannot be held guilty of nuisance. It would, of course, have been a different matter altogether if the question asked whether Sheila was guilty of nuisance. A passage may have more than one principle and more than one set of incidents. In some instances, the questions may ask you to apply the same principle to different fact situations, whereas in others, each question may relate to a different principle and fact situation. So make sure you pay close attention to each question, determine which principle and facts have been called into question, and only then attempt the answer. Finally, bear in mind that the question setters do not expect that you are a lawyer before you even go to law school. As such, it is important you do not try to apply any pre-existing knowledge of laws that you may have to the questions in this section. Very often, the question setters will tweak a principle of law here and there, with the result that the outcome may be very different from what you may know about some actual law in the real world. While you would be expected to have some basic knowledge of law, this is only at the level of a responsible citizen and member of our society. You should be careful not to let any external knowledge or information you may have creep into your analysis of the principles and facts supplied to you in the question. To help illustrate the different questions and the way to best approach them, let's go over an example where we can go through the passage together and then examine the rationale for the correct answers. The first clause in Article 20 of the Constitution prohibits retroactive criminal legislation. A person cannot be convicted for an offence which was not an offence at the time at which it was committed. The second protection in Article 20 is against double jeopardy and provides that no person shall be prosecuted and punished for the same offence more than once. The third guarantee in Article 20 is against self-incrimination or compelling a person to be a witness against herself. In Kati Kalu Oghad, the Supreme Court held that the prohibition against compelling a person to be a witness against herself related to the production of information based on personal knowledge, also called testimonial evidence, but did not extend to protection of physical evidence like a writing sample or a thumb impression, also called physical evidence. But can all situations neatly fit this distinction? A recent case, Selvi, provides a fascinating opportunity to revisit this distinction in light of new technologies. The case saw a challenge to the involuntary administration of narcoanalysis, the polygraph test, and the brain electrical activation profile test. Narcoanalysis involves the consumption of sodiopentothal, which lowers inhibitions and takes the subject into a trance, inducing her to converse casually. The other two tests detect physiological responses and brain activity, respectively, and estimate the subject's familiarity with information involving a crime through which conclusions are drawn. The passage we just read has been extracted with edits and revisions from the Indian Constitution, written by Madhav Khosla and published by the Oxford University Press. Now the exam requires you to answer the questions following the passage, assuming that the decision in Kati Kalu Oghad as set out in the passage is valid law. Let's move on to the questions. Mahmood Kaskar resided in the city of Mumbai and was long suspected of having committed several offences, including smuggling. Kaskar came across a police checkpost on the road on 15 December 2019 and, afraid that the police would find the contraband that he had hidden in the trunk of his car, he drove through the checkpost instead of stopping. In doing so, he smashed his car through the barricades at the checkpost, and a piece from the barricades flew a few feet away and injured a policeman manning the checkpost. Kaskar was later caught by the police and charged with the offence of obstructing justice, which the police claimed he did by crashing through the checkpost. Kaskar was acquitted of this charge since the police were not able to produce adequate evidence before the court. Some months later, the police, bent on teaching Kaskar a lesson, filed charges of injuring a police officer on duty against Kaskar. When Kaskar was convicted, he filed an appeal claiming that the decision violated the protection against double jeopardy in Article 20. Will Kaskar succeed? Your options are A. No, since the second charge filed against Kaskar was in relation to a different offence than the first one. B. Yes, since he had already been prosecuted for crashing through the barricades and could not be prosecuted for the same actions again. C. Yes, since he had already been acquitted the first time, charges were filed against him. Or D. No, since he was long suspected of having committed several offences. The correct answer is A. Here is the rationale behind that answer. The correct answer is A. No, since the second charge filed against Kaskar was in relation to a different offence than the first one. The passage tells us that the protection against double jeopardy is against a person being prosecuted and punished for the same offence more than once. Since Kaskar was being prosecuted for a different offence the second time, that of injuring a police officer on duty, than the first time, that of obstructing justice, the protection against double jeopardy would not apply in this case. Since the second prosecution involved a different offence, Options B and C cannot be the correct answer. Option D is irrelevant to the question and so cannot be the correct answer. Sometime after the two prosecutions mentioned in the previous question, the police managed to recover CCTV footage from the area near the place where the police checkpost was and filed fresh charges of obstructing justice against Kaskar for crashing through the checkpost. They claim that the CCTV footage would help them win the case this time. Kaskar claims that this fresh third trial violates his protection against double jeopardy in Article 20 of the Constitution. Will he succeed? Your options are A. Yes, since Kaskar is a citizen of India and is protected under Article 20 of the Constitution. B. No, since the police were able to bring fresh evidence before the court in this new trial. C. Yes, since he had already been prosecuted for the offence of obstructing justice and was acquitted. Or D. No, since he was prosecuted but not punished for the same offence in the first trial. The correct answer is D. Here is the rationale behind that. The correct answer is D. No, since he was prosecuted but not punished for the same offence in the first trial. The protection under Article 20 is against a person being prosecuted and punished for the same offence more than once. Since Kaskar had been prosecuted but not punished in the first trial, he would not have the advantage of this protection under Article 20. For the same reason, C cannot be the correct answer. While options A and B may be true, they do not address the issue of whether the protection under Article 20 applies in this third trial, and so neither A nor B can be the correct answer. Concerned at the increasing number of instances of rash driving in Mumbai, the legislature passes a law on 12th January 2020 making rash driving a criminal offence punishable with 3 months imprisonment. The police, who are hell-bent on punishing Kaskar by now, file fresh charges and initiate a fourth case against Kaskar, claiming that his act of driving through the police checkpost constituted rash driving. Kaskar now claims that this fourth trial violates the first clause of Article 20. Will the police succeed in this fourth trial? Your options are A. Yes, since Kaskar had injured a policeman when he drove through the checkpost. B. No, since driving through a checkpost does not constitute rash driving. C. No, since rash driving was not an offence at the time Kaskar drove through the police checkpost. Or D. Yes, since Kaskar had been prosecuted for different offences in the previous 3 trials. The correct answer is option C. Here is the rationale. The correct answer is C. No, since rash driving was not an offence at the time Kaskar drove through the police checkpost. The first clause of Article 20 provides that a person cannot be convicted for an offence which was not an offence at the time at which it was committed. Since rash driving was not an offence on 15 December 2019 when Kaskar drove through the checkpost, he cannot be punished for having committed that offence. While options A and B may or may not be true, they do not address the question of whether Kaskar's rights under the first clause of Article 20 had been violated, and so neither A nor B can be the correct answer. Option D is irrelevant to the question. It addresses the issue of double jeopardy rather than the protection under the first clause of Article 20, and so D cannot be the correct answer. While he was in custody, the police decided to investigate whether Kaskar was involved in the instances of smuggling that he was suspected of having committed. They asked him to produce a DNA sample that they could use to compare against the evidence they obtained from a boat suspected to have been used in such smuggling activities. Kaskar refused, claiming that forcing him to provide a DNA sample would violate his protection against self-incrimination under Article 20. Can the police force Kaskar to provide the DNA sample? Your options are A. Yes, since DNA samples amount to physical evidence and not testimonial evidence. B. Yes, since smuggling is a serious offence and Kaskar was already suspected of being involved in it. C. No, since producing DNA samples would amount to compelling Kaskar to be a witness against himself. Or D. No, since Kaskar had not been charged with smuggling at the time he was asked to produce the sample. The correct answer is option A. Here is the rationale behind that answer. The correct answer is A. Yes, since DNA samples amount to physical evidence and not testimonial evidence. The decision in Kati Kalu Oghad clarifies that the protection against self-incrimination under Article 20 extends to the production of information based on personal knowledge, testimonial evidence, but not physical evidence like a writing sample or a thumb impression. For this reason, C cannot be the correct answer. Options B and D may be true, but they do not address the question, and so neither can be the correct answer. Assuming that the Supreme Court was bound to follow the decision in Kati Kalu Oghad while deciding Selvi, what decision should the Supreme Court have taken in Selvi as regards the forcible administration of narco-analysis on a person? Your options are A. It would be constitutional since it is a new technology and is different from other techniques of extracting evidence like fingerprints or thumb impressions. B. It would be unconstitutional since it would amount to forcibly extracting testimonial evidence. C. It would be constitutional since it only has a physical effect and so would amount to extracting physical evidence. Or D. It would be unconstitutional since it puts a person in an abnormal state of mind where they cannot remember their rights under Article 20. The correct answer is option B. Here is the rationale. The correct answer is B. It would be unconstitutional since it would amount to forcibly extracting testimonial evidence. As the passage tells us, the administration of sodium pentothal would lower a person's inhibitions and take them into a trance, inducing them to converse casually, as a result of which they may provide information based on personal knowledge, testimonial evidence. While it may be a new technology and different from thumb impressions or handwriting samples, the forcible use of narco-analysis may result in the extraction of testimonial evidence, and so A cannot be the correct answer. While it may have a physical effect, the end result of forcible administration of narco-analysis would be the extraction of testimonial evidence, and so C cannot be the correct answer. While D may be true, it does not address the issue of whether the forcible administration of narco-analysis violates the protection against self-incrimination under Article 20, and so D cannot be the correct answer. Before ending this video, here are a few strategies and suggestions to help you prepare for the legal reasoning section of the UG Clat 2020. The legal reasoning, logical reasoning, and English language sections of the UG Clat 2020 are somewhat related in the sense that they all require you to read and comprehend a passage well. As such, some of the preparation techniques that apply to the English language and logical reasoning sections of the UG Clat 2020 may also serve you well for this section. See if you want to schedule your preparation time such that you focus on these 3 subjects as a group. Since this section of the UG Clat 2020 is somewhat different from previous years' papers, you may think that it would not be helpful to attempt legal reasoning questions from previous years' papers. However, this would be a mistake. While the previous year's questions may not ask you to pull out a principle from a passage and may instead supply the principle directly to you, there is still great value in attempting those questions since they will help you develop the skill of analyzing a principle, examining a fact situation closely, and applying one to the other. The sample questions and model papers provided by the Clat Consortium would of course be one of the best sources of preparation. If you are already familiar with the pattern of these questions from the sample questions or the first model paper, consider attempting this section in the later model papers, in something similar to an actual test environment. Time yourself and make sure you do not take any external help in attempting these questions. Then, analyze the results and try and determine what's going right and what isn't. Are you able to pull out the principle but not break it down? Or are you able to deal with the principle easily but can't understand the fact situations properly? If the first, perhaps some extra work on logical reasoning may help. If the second, maybe you should spend a little more time on the English language preparations. For more information on sample papers, syllabus, or the exam, do visit our website www.consortiumofnlus.ac.in.